Hi, and welcome to this latest immigration law update video. In this video, I wanted to look at the latest Court of Appeal looking at the long residence rule in 276B. I think we all thought the judgment of the Court of Appeal in Hoque had pretty much cleared up and settled things, but this muddies the waters, and I think there's going to be more to come. So important judgment. It's a case called Afzal, and it was handed down on the 17th of December 2021, and I've shared my screen so you can see the judgment of the Court of Appeal, and I'll put the link to the judgment below this video. But I'm recording this on the 21st of December 2021, so do watch this space for forthcoming judgments which clarify this area further. So this concerned an application for indefinite leave to remain on long residence grounds. Judgment of the Court of Appeal by Sir Patrick Elias. The application for ILR was made on the 28th of February 2020, refused on the 11th of March 2020 on the basis that there was a period when the appellant was not lawfully resident in the country, so that his period of continuous lawful residence had been broken. An application for JR refused on the papers and at an oral hearing by Upper Tribunal Judge Stephen Smith, appealed to the Court of Appeal, rolled up hearing before the Court of Appeal. So Patrick Elias indicated that they would grant permission. So effectively the appeal was a consideration of the substantive judicial review. So Patrick Elias sets out the chronology, and the important parts in the chronology are the July 2017 application. So look at paragraph 3, an in-time application, July 2017, and that was rejected as invalid by a notice of 22nd January 2018 for the failure to pay the immigration health surcharge. Now, bear in mind, at the time the appellant made that application in July 17, he also applied for a fee waiver. Have a look at paragraph 4. The fee waiver was rejected 18th October 2017. He paid the fee, but for some reason failed to pay the immigration health surcharge. Was sent a letter on the 8th of November 2017, giving him 10 working days to pay. That expired on the 22nd of November 17, and he hadn't paid. And then it led to the rejection on 22nd January 2018. Then we come to the fresh application, paragraph 5 of February 18, which led to him granted leave until 2022, which allowed him to make his ILR application on the 28th of February 2020. Those are the key dates which I'm going to come back to as we look at the judgment. Lord Justice Elias sets out the requirements of 276B and other rules around that area, and also paragraph 39E of the immigration rules, which obviously provides the exception for overstayers and includes 39E 2B 1 and 2. So there's a disregard where you make an application within 14 days of a refusal of a previous application for leave, or the expiry of leave under section 3C of the Immigration Act 1971. That's the statutory extension of leave when you make an in-time application. There's a quote there from the Supreme Court in Mahad, a consideration of the decision below, and then we come to the discussion. So the key issues in this case were threefold. Firstly, was leave extended by virtue of section 3C, or did 39E apply and any overstaying could be disregarded? And if that overstaying was disregarded, does disregarded leave positively contribute to the 10 years lawful residence? So 3 issues. First issue, does section 3C apply to the period from 17th July 2017 to the 22nd of January 2018? And in doing this, there's a consideration of the judgment of the Supreme Court in Mirza. Sir Patrick Elias looks at the relevant order, which is the Immigration Health Charge Order 2015, which requires the immigration health surcharge to be paid and provides that it can be paid within 10 working days of when a request for payment is sent out in writing. Consideration of the Mirza case. And at paragraph 32, Lord Justice Elias says this: he adopts neither of the positions of the appellant or the Secretary of State. That's why I haven't gone through what their positions are. But he said, if the obligation to pay the fee is not in dispute, so if it's a case that there's not a fee waiver application and the fee is not paid, the application is invalidated ab initio, from the beginning, unless the fee is paid within that 10-day period of grace that's built into the process. And that validates the application retrospectively. But if you don't pay the fee, you don't get sort of 3C extending your leave for that 10-day grace period, it's invalidated from the beginning. So 3C doesn't bite. But if you pay within the 10-day period, then it's validated retrospectively and your leave is statutorily extended during that period. What about if there is a fee waiver application, paragraph 33? He says, well, in this case, I don't think it can be said that if it's not paid, it's invalid ab initio. What he finds is that an application is conditionally valid and then until an obligation to pay the fee is imposed following a refusal to grant relief. So it's conditionally valid until then, if the fee waiver is refused, is that then the obligation is imposed. And if the fee is not paid within the specified period of 10 working days, the 3C leave then ends. So the best way to illustrate this is what happened in this case, that the fee waiver application was rejected. There was then a request to pay on the 8th of November 2017. Look at paragraph 38. 10 working days was given until the 22nd of November 2017, and it was not then paid. So the appellant's leave, statutorily extended leave, expired on the 22nd of November 17. What was the upshot of all that? Well, the February 2018 application, which was successful, was therefore more than 14 days after the expiry of 3C leave. So the appellant couldn't benefit by paragraph 39EB2. But then the alternative argument was raised, was 39E2B1 engaged? Now 39E2B1 is where an application is made within 14 days of an application being unsuccessful. Now, we know on the 22nd of January 2018, his first application was rejected as invalid. And then he made the February application thereafter within the 14-day period. It was argued by the Secretary of State that section 39E2B1 doesn't include invalidated applications which are rejected. But on this issue, and this is the helpful part of this judgment, Sir Patrick Elias finds that the word application in 39E includes invalid applications. So his application in February had been made within 14 days of his rejected application on the 22nd of January 2018. So paragraph 39E applied, and following Hoque, that whole period of overstaying then fell to be disregarded. So really helpful. 39E applies to where an application is rejected as invalid, because he then made an application within 14 days of the application being rejected as invalid. 39E applied, and there was the disregard to this bookended period of overstaying following Hoque. But does this disregarded period positively count towards the 10-year requirement in 276B1A? The majority of the Court of Appeal in Hoque had said yes, but in this case, Sir Patrick Elias disagrees. Look at paragraph 70, and he finds the fact that it's disregarded effectively means it just doesn't set the clock back to zero, and your continuous lawful residence is not broken, but the disregarded period doesn't positively count towards the 10 years. He also looks, paragraph 71, at the upper tribunal decision in Muneeb Asif, and I've referred to that in previous videos. In that case, upper tribunal Judge Blum had rejected the argument of the Secretary of State that a disregarded period doesn't positively count towards the 10-year period, and he'd followed the majority of the Court of Appeal in Hoque and said, yes, this disregarded period did count towards the 10-year period. But again, Sir Patrick Elias disagrees with the approach of the upper tribunal in Muneeb Asif. So the upshot is paragraph 87. Don't worry about paragraphs 84 to 86. There were some other grounds of appeal about the refusal of the upper tribunal to adjourn, which doesn't need to trouble us in this video. So what the conclusion of the Court of Appeal is, that there was this gap between the 22nd of November 2017 until the 5th of September 2019, but it failed to be disregarded. So it didn't break the continuity of lawful residence, but it didn't positively count to the 10 years. So the Secretary of State was right to reject the application for indefinite leave to remain. Now, by the time this case came before the Court of Appeal, the appellant had probably built up the 10 years continuous lawful residence, but that didn't matter for the purposes of the JR. So there's good and bad in this case. The good is the approach to 39E and the inclusion of invalidated applications, and then the disregard being applied there where new application is successful within 14 days of an invalidated application. But the bad is the disagreement with the majority in Hoque and the disagreement with the upper tribunal reported decision that disregarded periods do not now count towards 10-year lawful residence. So it doesn't break the continuity of the lawful residence, but it doesn't positively count. It's a shield rather than a sword, effectively, and that's what Sir Patrick Elias says. So given that the Court of Appeal disagree with Hoque, given that they disagree with the upper tribunal reported decision, I doubt this is the end of the matter. And perhaps this is going to need to trouble the Supreme Court to get some proper clarification on this issue. But an important judgment that needs to be looked at and may well affect you or your clients, given the approach to disregarded leave. So I hope that's helpful to you.